This video is about a family who lost their 16-year-old son in a catastrophic wrongful death case. In the video, we share the facts of this tragedy with you and also walk you through the litigation and jury trial process. After you listen to and watch this video, we hope you'll have a new appreciation for the reality of what it takes for a client and a lawyer to successfully handle a civil wrongful death case. If you were to go back in time, you would find our clients looking forward to spending time at their vacation home in Lake Havasu, Arizona. In fact, there was nothing they enjoyed doing more than spending time together, water skiing, jet skiing, and doing other fun water-related activities on the Colorado River, and in the evenings watching movies late into the night. After arriving at the river, our client's 16-year-old son and his teenage cousin decided to explore the Colorado River on their jet skis. And so, as they had done so many times in the past, they launched their watercraft and headed up to the river. They headed north, and the two boys arrived at a reed-lined channel next to the river, and they entered this area at a speed of between 5 and 10 miles per hour. As they approached the first sharp left-hand turn, another watercraft came from the opposite direction, unexpectedly flying around the corner at a high rate of speed. Before our client's son could take evasive action, he was struck head-on and killed. This untimely and unnecessary death was avoidable, and the family struggled about what they should do next. They trusted the local police authorities to properly investigate their son's death, but several weeks later were extremely disappointed to learn that the investigation determined that their son was the cause of the collision, and he had a positive blood alcohol level in his system. After being advised of this information, the family came to us for help. They told us their son did not drink, smoke, or do drugs, and at the time of the collision, he was an expert jet ski rider. They had talked with witnesses who confirmed the other watercraft operator caused the collision. Putting two and two together, they felt it was the local town and local authorities who had possibly conspired to cover up the true facts of this incident. We believe our client's version of the story and filed a wrongful death lawsuit in the Superior Court of the state of California. The defendant, a 52-year-old retired naval officer, and his insurance company used a procedural tool to have the case removed to federal court. From a practical standpoint, this made things a bit more challenging for us because rather than having to convince 9 out of 12 jurors that the defendant was negligent and caused the death of our client's son, we now needed to obtain a unanimous jury verdict in federal court. During the litigation, the defendant boat insurance company denied responsibility. They denied that their insured was the legal cause of our young client's death and offered the insulting figure of $1 to settle the case. This offer was a slap in the face to our clients. We were asked to do everything we could to right this wrong, and so we did. During the discovery portion of our case, we learned that the local police department had supposedly gotten the blood test mixed up with another person who had nothing to do with our case. Through a bit of hard work and legal effort, we were able to get this police department to confirm that at the time of our young client's death, he did not have any alcohol or drugs in his blood system. So far, so good. We traveled back and forth from Orange County, California to Lake Havasu, Arizona to investigate the facts, interview witnesses, and take depositions. During this process, we found 2 eyewitnesses to the collision. They told us that our client did nothing wrong and that the defendant was racing his jet ski at an extremely high rate of speed and unsafely tried to maneuver around the blind reed-lined corner and cause this collision. Now here's the interesting part. Despite these 2 independent witnesses and this new evidence, the defendant and his insurance company refused to budge off their earlier $1 settlement offer. We eventually took this case to trial in federal court in Santa Ana, California. Just before trial, the defendant's insurance carrier increased their settlement offer to $20,000. Our clients instructed us to reject the offer and try the case in front of a jury of their peers, and that's what we did. During the trial, we presented our client's version of what happened, and the two independent witnesses testified before the jury. The defendant had spent a great deal of money and hired an expert accident reconstruction and helicopter photography team to try to show the jury that the defendant did not cause this collision. For whatever reason, the defendant and his lawyer completely disregarded what our two independent witnesses saw and testified to. In our opinion, the real problem for the defendant in this particular case is that the accident reconstruction experts had placed the location of the collision at the wrong corner in the reed line channel. Everything that they testified to during trial was based upon testing and measurements and photographs taken at a location other than where our client's family and the independent witnesses testified the collision took place. During the trial, the defendant tried to also argue that our client's son assumed the risk of harm while riding his jet ski, and that under the law, the defendant could not be held responsible for the death. We countered with the argument that at no time did our client's son ever assume that another jet ski rider would be careless and operate his watercraft at an unsafe speed in such a narrow reed-lined water channel. To the contrary, our client had a legal right to expect other watercraft operators to conduct themselves in a safe and lawful fashion, and our trial judge agreed with us. In the end, the federal jury got things right and awarded our client a gross wrongful death verdict of $1,250,000. Now, what's important to remember in this case is that the family knew their son had done nothing wrong, and they gave us all the time we needed during the litigation process to prove our case. They didn't rush us or make unreasonable demands on us. They told us to do what we thought we needed to do to get things done correctly and to maximize our chances of success. And that's exactly what we did. Looking back, it took a great deal of effort and resources and a lot of hard work to get this verdict for our clients. But I'm going to fill you in on a little secret. It didn't feel like work at all. When you believe in people you're representing, when you believe in a cause that you're litigating, it's simply a pleasure to have an opportunity to help. If you have a legal question or matter and would like to get your questions answered, then by all means, give us a call. We've been helping victims of personal injury and wrongful death since 1986, and chances are we can help you too.